Looks to be 3 o'clock on the East Coast on the button, so why don't we get started? Thanks for joining this Track B session of the PreVeil CMMC Summit. We're here to talk about DFARS, CMMC, and in particular, the relatively new and scary Civil Cyber Fraud Initiative with a great expert who can help us navigate all this. You probably saw Bob in the general session, but for those of you that didn't catch the introduction, Bob's an attorney in private practice. He is really well regarded in all kinds of cybersecurity matters. We at PreVeil have gone to him for advice on many things, and has really been a great expert for us. He was counsel of record for Microsoft in the federal claims court litigation over the JEDI protest litigation. He advises world-class technology companies just like us in enterprise strategy and compliance matters. He's a consultant. He was a consultant to the MITRE Corporation, which is a federally funded R&D center, and in 2018 was co-author of the Delivered Uncompromised report, which focused on the security of the defense industrial base, and I think was also one of the inspirations for CMMC and a number of other activities. And he's done a lot of work in public-private projects involving cyber, supply chain, and security. So please join me in welcoming Bob Metzger. Bob, how about we start with you kind of helping us understand the Civil Cyber Fraud Initiative, telling us how scary it is or should be, and how small and medium businesses in particular, need to understand, pay attention, and what actions they should be taking given this initiative.
Thanks. First, I still am a consultant to MITRE. I do a variety of things involving public-private initiatives on security subjects. Second, moments ago, I managed to spill a cup of coffee, which is now seeping into the rug underneath my desk. I'm going to elect to continue here rather than attempt to solve that problem. So, you said that the False Claims Initiative is scary. I don't think it's scary if you are doing the right thing. I do think it is of concern, and it certainly should draw the attention not only of the CISOs and CIOs, but of those within a company who have responsibility for governance, risk, and compliance. So let's talk about what it is, what have they announced, and then where it might affect the companies who are subject to the DFARS 7012 regulation. And then if time permits, we'll get into some of the complexities or mechanics of the False Claims Act. The short version on the last point is that it is easier to allege a fraud in the area of cyber than it is to prove it. There's been relatively few cases that have been brought successfully. There are some reasons for that, which remain true to a bit lesser extent than before this initiative. But I will say this, the reason that you should be concerned isn't that you are certain to be liable for damages to the government after a successful False Claims Act action is brought and goes to trial. The number of cases are probably going to be relatively few. The reason you should be concerned is that the government now says that it is going to take greater efforts to enforce the False Claims Act. It has set some of the objectives that it has, and some of them are quite challenging for us. And the government is actively encouraging whistleblowers to come forward. And if a whistleblower comes forward under the False Claims Act, it might persuade the government to bring an action in its own name against your company. Or if the government declines that action, whistleblowers can and do proceed by themselves. They're called relators in a suit brought on behalf of the government against the entity that is defending and is accused of false claims. Whistleblowers have a pretty powerful incentive to blow that whistle. One is that they can receive a pretty substantial fraction of the amount of damages and penalties that are paid by a cyber defendant. Also, it sometimes happens that after an individual blows the whistle within a company, or rather, let me say more precisely, it sometimes happens that there can be dissent within a company where the person later to become the whistleblower feels that his views were rejected and that he was treated badly. And sometimes those people find themselves dismissed from their position. Well, if that happens, then the whistleblower suit includes not only the allegations of a false claim, but also allegations that there is an illegal, improper retaliation against the whistleblower. As I said this morning, one of the best reasons to do the right thing is to avoid even the exposure to a False Claims Act action. Although there are a variety of intricate defenses that can and are asserted when these claims are brought, it is expensive to defend a case. If a case is raised against you, you have cost of investigation, substantial cost of lawyers. If the case happens to go to trial, it can be enormously expensive and time consuming and highly disruptive to your management and technical personnel. And it is process definitely to be avoided. There is no money gain and much loss if you find yourself on the receiving end of a cyber fraud allegation. So you want to be careful to avoid the circumstances that would create it. Now I can say the obvious, which is that everybody that does the right thing with a proper intent, shouldn't worry too much. But in the real world that we live in, there are so many complexities, even in the existing DFARS rule and in the potential CMMC regulation and assessment. There's so many complexities where there can be things where there can be significant, substantial, even intense disagreements within a company as to what is right or wrong to do. And we do have circumstances, unfortunately, where some companies have felt that they'll just take contracts with the clause, that they will submit a self-assessment score, that they will promise a time when they will close all gaps in their security, and they figure that nothing will come of it and nobody will do anything. Well, maybe. I mean, it's also maybe possible that if somebody does something and it happens to be the Justice Department or an Inspector General or a whistleblower, the money that you saved by taking the position of avoidance is going to be dwarfed by the money that you spend in trying to defend the False Claims Act action. Well, let's start with kind of what this thing is. It was just announced about 3 weeks ago, a little more than 3 weeks ago. The opening comments of the Assistant Deputy Attorney General, Lisa Monaco, in announcing this initiative was that for too long, companies have chosen silence under the mistaken belief that it is less risky to hide the breach than to bring it forward and report it. Well, a common theme in this part of the discussion, there are two common themes. One is that here DOJ is getting behind the initiative of the President as expressed in the May 12, 2021 Executive Order 14028. That executive order puts tremendous emphasis upon the importance of timely disclosure of information security events. And the second theme is that as we listen carefully to what is said by the leading DOJ representatives, those of us who are skilled in the security field are going to be thinking that there are lots of disconnects and mismatches, overstatements, and misimpressions in what they are saying. And you're right if you reach that conclusion. But if DOJ is determined to be more aggressive in pursuing cyber fraud, if they are actively encouraging whistleblowers to bring it to their attention, if they are more disposed to investigate allegations when they are made, even if there are peculiarities or nonconformities in their thinking, it's not going to help you should you make the wrong decision and find yourself on the receiving end of this initiative. So going on with her initial statement, she says that it is to hold accountable entities or individuals that put U.S. information or systems at risk. Now, that's important because we're not talking about contractor information systems except to the extent that they are hosting U.S. information. And that gets us into that area of, well, what is that? I mean, is any form of CUI that you may hold U.S. information? It's a question that hasn't quite been resolved because, in theory, the CUI that the government gives you could be U.S. information, but the CUI that you may feel that you have to designate, which you created yourself, could be covered by that DFARS reg, but not U.S. information as is intended here. It's a fine point, and it really goes into that basket of, the peculiarities and defenses. She goes on to say that they want to hold entities of individuals accountable where they knowingly provide deficient cybersecurity products or services. Well, this is another one of these aspects of disconnect, because really they're talking about separate things. One thing is that if a contractor is providing cybersecurity services or products to the government, they want them to work or they don't want them to be defective, fine. But many of the companies that are listening to this call don't provide cybersecurity products, do provide other products and services, and in those contracts are expected to meet cybersecurity standards. So I think there's sort of a duality. If you happen to be supplying systems and cybersecurity techniques or services to the government, you got to be careful. But if you're just providing services and are required to secure information, you still have to be careful. She goes on to say that one of the things that she also goes on to say that they're looking for folks who knowingly misrepresent their cybersecurity practices or protocols. Well, that's another peculiarity, because you can have cybersecurity practices and protocols that are independent of anything the government requires. But to the extent that you are making a representation about them or relying upon them in bidding on or receiving a contract, well, then your practices become something that is the basis for an affirmation or a representation, which in turn the government could say that it relies upon. And if you were false in that representation, they might say there was fraud in the inducement that led them to give you a contract that you might not have otherwise. This is called promissory fraud. Now, let's go on to another thing. This is the first kickoff meeting. Deputy AG Monaco. She's going after people who knowingly violate obligations to monitor and report. Well, those are actually two kind of different things. I mean, monitoring is what you do to be informed of the status of your network and whether a breach occurs. And reporting is what you do if you know, when you know, and what you do upon that knowledge. Now, you know, you can see that she's kind of expanding the envelope, because she doesn't want companies to say, we didn't monitor our network, we had no idea this terrible thing happened. And therefore, if we aren't aware of the cyber event, then we can't be held to knowingly fail to report it. In other words, there are some who might say, well, let's see, the less I know about what's actually happening to my cyber network, well, the less I have to disclose. But you don't know, you can't tell. And here's where the government is saying, we don't think so. If you have a network and you're under a government contract and you are in some form expected to or required to monitor it, you cannot do, deliberate blindness or willful blindness. You're going to have to both monitor and report. And then she goes on to state the benefits of this. She wants to, DOJ wants to build broad resilience against cybersecurity intrusions across the government. Well, that's interesting, because you don't actually enforce the False Claims Act against the government, you enforce it against contractors. But that extends to industry partners. Well, the False Claims Act has ways of making people comply with their obligations, but whether those obligations include particular duties in the nature of resiliency, well, it's an aspiration, but maybe not a perfect fit. They also want to hold contractors and grantees to their commitments to protect government information and infrastructure. Well, some of those commitments will be in special contract clauses. If you have them, you'll know them, but some of them will be in general clauses like the DFARS. And if there are commitments that you're called upon to make and you knowingly fail to make them, you could have a problem. Now, what is knowingly? It certainly includes purposeful activity. I understand the requirement, I decide not to do it. Knowingly can also include acting in reckless disregard of what you understand to be duties. The simple example of knowing is that, say, you submit an SPRS score following your DoD self-assessment, and you cheerfully assign yourself a 100% score, knowing that your actual score is minus 46. If you do that on a knowing basis, you have misrepresented something to the government that could generate false claims exposure. But knowingly can get hard in some areas, because if we look at just the 110 requirements in 171, and then we take a step into 171A, the assessment guide, and then maybe we take a further journey into maturity level 3 for CMMC and its assessment guide. And then we consider all those things in the context of the scoping guidance, which has yet to appear. Well, suddenly, there are an awful lot of things that you may be required to do where there is a lot of room for doubt as to what exactly the requirement is and which way among several choices is necessary, or whether several are permitted. again, the fact that we can nitpick and find all these peculiarities or particularities in the DOJ's announcement does not actually mean that you shouldn't take this seriously. You don't want to make an error that's going to produce that whistleblower or cause DOJ or the Inspector General to show up. They also say that they want companies to support government experts' efforts to timely identify, create, and publicize patches. Well, that's fascinating. I completely agree as a matter of cybersecurity policy. But there's actually not too many contract clauses for ordinary participants in the defense industrial base that actually tell you that you are supposed to identify vulnerabilities or exposed weaknesses and that you are to timely report them. And I'm not aware of too many actual obligations to remedy them. You should do that. It is really smart. A known vulnerability or a new weakness is something that people can and do exploit against you. But how you turn that into feed for the False Claims Act is a little hard, because if there's no underlying duty or contractual obligation to do so, it's a little hard to say that by taking a contract, you are defrauding the government by not doing something it doesn't require you to do, but hopes you'll do, if you follow me. It says that it wants to ensure companies that follow the rules and invest in meeting cybersecurity are not at a competitive disadvantage. Well, I certainly agree with that. I mean, this has been a real problem, because companies will feel, gee, if you're a medium-sized business and suddenly you got to spend 10% of your annual revenues, or 5%, to take these measures to secure yourself, you don't want to find that by doing the correct and required thing, suddenly you are at a competitive advantage and don't get the contracts that people who ignore these requirements do. I'm all for it. But that is a byproduct of an eventual enforcement campaign rather than anything that actually influences the immediate behavior of any company. They also want to reimburse the government and taxpayers for the losses incurred when companies fail to satisfy their cybersecurity obligations. Well, it makes sense. But I mean, in the real world, what exactly are those losses? How often do we know what they are? I mean, there can be a situation where you know of an event, but you don't know it's a breach, or situations where there is a breach, but you don't know whether anything was exfiltrated, and situations where you know something was exfiltrated, but you don't know what exactly, or you don't know who got it, or you don't know whether they did anything with it. And so it's possible that you could have a chain of events going from incident, event, breach, exfiltration, loss of data without any actual damage being experienced by the government. That could happen. And even if the Chinese, for example, were to steal information from you that is controlled and classified information, they might sit on it for days, or we might have no way of knowing whether they use it. So as a practical matter, it's not likely in many cases that the government will be able to show, using conventional theories, that there are damages. But if and when it can, it has a right to collect treble damages for the damages actually occurred. But that shouldn't give you too much comfort, because the False Claims Act also allows the government to impose penalties for false invoices. And if they take the theory that each invoice that you submit following a false or fraudulent claim relating to your cyber performance, if they say each one of those is an actionable violation of the False Claims Act, they can charge you between $11,000 and $23,000 as a penalty per invoice. And if you have a lot of invoices, that's a big number, and you don't want to go there. Now, there's a number of statutes that are pending that are looking to increase the requirement and extend it for prompt cyber incident reporting. And some of those statutes would have their own fines for failure to report. And if those apply to you, then those fines might become something that's subject to an FC action. They say they want to improve overall cybersecurity practices to benefit, the government and industry. Well, that's what this is really all about. I mean, the False Claims Act is frankly a pretty crude tool to get companies to improve their cybersecurity practice. But I think it will have an impact nonetheless, because the governance, risk, and compliance people, and those like the general counsel, or those companies who listen to outside counsel, when there are questions as to whether we do nothing or do a little or do more, say nothing or say something, when those kind of questions arise, suddenly you're going to think, I don't really want to take the easier or cheaper course, because I may be assuming a risk, of such enormous consequence and cost to the enterprise that if the better decision is in fact to spend more, do more. We'll see. Now let's go forward a little bit of time here to another announcement by the Department of Justice. This one was on October 13th. by the acting assistant attorney general, Brian Boynton. And he goes into a little bit more detail, and we still have some of these, I call them particularities. I'm not sure it's a word, but if it isn't, maybe it should be. So he says, okay, protecting against malicious cyber campaigns is a matter of national concern, and it's a top priority of the administration. He refers to the executive order, which announces that the prevention, detection, assessment, and remediation of cyber incidents is a top priority. I'm all for that, and I've studied the executive order a lot, but there is a huge separation between the great pronouncements and ambitions of the executive order and the details of what you, as a company subject to DFARS or other regulations, have to do. But that confirms my point earlier that this is about, DOJ kind of coming into the ring and doing what it can to get better performance on cyber where it can. It's not going to solve the problems that are in the EO, but it may help to better, to improve the cybersecurity of the defense industrial base. So he goes on to say that, some of you know the framework, right? The NIST framework. What is it? Identify, protect, detect, respond, recover. It's like an article of faith. Well, here, Mr. Boynton says we're going to identify, pursue, and deter cyber vulnerabilities. And we want to avoid putting at risk sensitive information in government systems. All good causes. Actually linking these things to what we're supposed to do, a little harder. He reminds us that they can recover 3 times their losses if they can prove it. And then he goes into a long discussion about whistleblowers. And this, again, is really important because what it's telling all the people out there, they could be your consultant, they could be a CISO, they could be somebody on your technical team. There are a lot of people who may have ideas that an enterprise disagrees with, who could decide they're unhappy enough or they're greedy enough that they want to become a whistleblower and, make that call or check in at the website. The Attorney Inspector Generals have a really handy website. I took a look at it last night. Doesn't take much to get there. And you really got to consider, not just what the CS. You don't want to consider the least cost choice if there are people who are informed and knowledgeable who are urging you to do something more and different because of that whistleblower risk. The Department of Justice says that apart from the whistleblowers bringing to their attention things they might not otherwise know, they say that whistleblowers bring considerable technical expertise, and this is a point as well. Because if the whistleblower is a CISO, as has happened, or a CTO, as has happened, well, they're not only going to be able to blow the whistle, but they're going to be able to tell the government kind of what was wrong and why. Now, let's talk about what he identified as the 3 common cybersecurity failures that are prime candidates for potential False Claims Act enforcement. The first is knowing failures to comply with cybersecurity standards. The second is knowing misrepresentation of security controls and practices. And the third is knowing failure to report suspected breaches. Now, if we think about those and then sort of wrap those, or mix those into the requirements of the 7012 clause, or 70, 19, and 20 for that self-assessment, you can see that there are quite a few junctures where you could be called upon to take actions, whether they be in how you self-assess and self-report, or what you're actually doing to maintain and sustain security, or what you are reporting or not. You can see how those 3 common cybersecurity failures could put you into that domain of where the DOJ might have interest. You may not intend to do any harm to anyone, but that standard of intent, which is important, it isn't what you subjectively think at the time. It's what a reasonable person looking at your conduct might infer or deduce as to your intent. So, for example, if you are doing that self-assessment that's required by the 7019 DFARS clause, and you have an SSP, and you come up with a number of -46 for your score, if you nonetheless proceed and put in a score of 82, well, you might be thinking no harm, no foul, but somebody looking at that on a jury is going to be thinking, hey, they knew it wasn't 82 and they did it, and that is a knowing improper act. And by the same token, recall that under that self-assessment clause, you're required also to provide a date when any gaps that you identified in your system security plan will be closed. Well, if you put in, we're going to have this done by 11/2022, and you have no intention of doing that, do nothing to accomplish it, and essentially put the number in to make yourself feel good and avoid any questions by a contracting officer, that's another example that could be a knowing misrepresentation. Now, failure to comply with cybersecurity standards. Well, how do you know? I mean, let's just focus on just that one. So suppose that you have submitted a CIPR score. Suppose that you are under the 7012 clause. Suppose then that you are the unlucky victim of a nation state attack upon your information system that steals really valuable unclassified information on an emerging or weapon system that is once in development. These things have happened. Well, suppose that happens. Well, I mean, in the situation where the government learns of it, you are virtually certain to get some form of investigation to determine what happened and why it was stolen. Now, the incident report requirement of 7012, it says you have to tell things within 72 hours. My understanding is that very few incidents actually have been reported, and there's a widespread perception within DoD that contractors are setting the bar much higher than DoD wants in terms of what they decided is an incident and how much they report. I think we will see that change in part because of this initiative. And so you've got that potential double risk. One is that the bad event happens. The first risk is that you maybe didn't have the cyber controls you should have had or said you had. And then the other is that you didn't report on time. And if you get into an investigation following a breach and there's harm to the government, well, they may well be looking to your system security plan as it existed when you took the contract. Suppose you don't have it, that's a problem. And then they're going to look, suppose you do have it. They'll look at that system security plan and they're going to say, you said you would have these 3 things for identity and access control, and these things for endpoint device management, and these things for event monitoring, and you had none of them. Well, I mean, in that situation, they could find that you knowingly misrepresented your compliance with cybersecurity standards. And they also might find that you didn't monitor sufficiently and you knew it or should have, and that you didn't report sufficiently and you knew it or should have. All of those things kind of get you into that zone of hazard. Now, I don't have enough time to cover all this, but we're getting into a few of it. Look, does this mean that, every company should live in fear, today and tomorrow and the next day that they're going to be subject to a False Claims Act? No. I mean, you start by doing the right thing. But there can be many situations where the right thing isn't clear or where there's disagreement, debate, dissension. So it's always good to have open debate. If necessary, bring in expert third parties. Have a documented basis for your decisions. Don't be in a situation where everybody suffers in silence, takes course A, where somebody in the company advocated for course B. If it happens that that course B becomes the subject of a whistleblower action because you didn't do it, well, what you're going to want if you get a call from the IG or the DoD, you're going to want to say, look, yeah, we knew that this was an issue, and we got a consultant, and here were our internal studies, and you want that documentation at the time. You never, ever want to be in a situation where you're trying to explain or justify behavior that is under investigation without documents that were contemporaneous to when you made the decisions that are at issue. Because trying to come up with explanations and document them after the fact is a recipe for trouble, and you don't want to do it. And I want to make this kind of final point. Look, one of the things that you have one thing that's important for whistleblowers is that they be the original source of the particular problem, that gives rise to their allegation of fraud. Well, if you are a company and you've submitted a CIPRS score and you find out it's really wrong, or you find out you can't make that POAM closure date or gap closure date, or you find out that there's this big disagreement as to some really challenging problem with your system, if you, the company, inform the government of those issues and inform them of how you are going to address them, well, in that case, you are the source of that information. You have informed the government. It's hard to misrepresent or defraud the government if you told them what the problem is, and it could deny that whistleblower an opportunity to claim that he or she has a right to bring such a suit. So one final point in the minute that I have. One of the big defenses to false claims action that have been used in the few cyber suits that have been pursued so far is that whatever I did wrong in cyber really isn't material. Nobody can do it. The government knows nobody can do it. The government gives me contracts even though they doubt I can do it. They continue to pay me even if they know that I'm not doing it. There's a case called Markham, which is litigating some of this stuff. One import of Deputy Attorney General Monaco's announcement and this new initiative is it's going to be easier for the government now to show that your failure to fulfill cyber requirements is material to their decision to contract with you. Because if the government at this level announces that we are determined to enforce the false claims and to make you comply with cyber requirements that are in your contract, the government has a much stronger case to argue that it really does matter that you, in fact, do as you say, perform as you promise, report as you know. And that could prove to be significant. I hope everybody finds this useful, very complex area. Glad to have a chance to talk about it.
Thank you, Robert. That was quite a drinking from the fire hose bit, but extremely informative. I had a bunch of questions along the way, but actually you answered a bunch of them. Unfortunately, we won't have time for Q&A before our next session, but I did like the takeaways that there's some things to be concerned about, what I took away, some things to be concerned about. One needs to very much, do what one says and document that accordingly. When in doubt, deal with a more stringent standard. And I also really liked your point. When in doubt, either disclose, which is your friend, a disclosure can be your friend, or also get a third party involved and document that shows that you're taking the issue seriously and that you're getting a pair of outside eyes to better get guidance on the issue. So I thought all of that was very helpful. So thank you for that tour de force. It was quite informative, very helpful, and appreciate your time with that.
Thank you.